Ms. Ellen, I understand you're representing yourself, is that correct?
Yes, that's correct.
Okay, and you're not an attorney, is that correct?
No, I'm not an attorney.
Okay. Do you have any questions about anything you don't understand before we get started?
Not yet, I don't. I
Okay,
believe I
well,
understand.
once you start, it's going to be a little, we can't stop at that point in time, but is there anything that,
I believe I understand.
okay, all right, what we're going to need to do when we start is, if you will, those lights will come on, and if you'll just give us your name, then you can just tell us whatever you want to about your case. I also need to know if you want to have any rebuttal time. You don't have to have any, obviously you can.
Okay.
So, Miss Angie. All right, you may proceed.
Good morning, Your Honors. My name is Katrina Allen. I'm appearing pro se as the appellant, and I would like to request 3 minutes for rebuttal.
3 minutes? All
Yes.
right, go right ahead.
All right, I am asking the court to reserve the Rule 12 dismissal and remand so the case can be heard on the merits. This case is a contract performance dispute. There's a utility service contract relationship. I agreed to pay for services when I applied for service, and JEA agreed to provide service and to accept and process payments through its billing system. The trial's court order itself recognizes a valid utility service contract exists. I can prove the key facts that make this a real dispute. It started on August the 7th of 2024. I sent tender payment materials by certified mail to JEA's CFO. JEA's billing department issued a written refusal dated August the 21st of 24. I then emailed again on January 25th of 25.
What payment material did you tender to them?
A tender, a payment of performance.
And how
So-
did you do that? Was it in the form of a check, a draft, a cash, or what?
It was in the form of a check.
Okay. And what type of check? Was this payable on your account or someone else's account?
It was a negotiable instrument.
Okay. Now, what is a negotiable instrument, though?
So the negotiable instrument that I used was the billing statement. So
That's a negotiable instrument?
yes, that was presented, yes.
The billing statement that they sent to you?
Yes.
Explain it to us. How is that considered a negotiable instrument?
So as far as me turning it into a negotiable instrument, I wrote on it, it had paid to the order of bearer. It gave a fixed amount that needed to be paid. And then I wrote on the back of it, I signed it unconditionally, saying that it was paid to the order. Let me start over. On the back of it, it was signed by me without recourse. So I followed all the steps of the negotiable instrument up under the UCC code that makes it negotiable.
Now, let me make sure I got this correct now. The billing that was sent to you for services that was rendered by the company, that can be transferred or changed into a negotiable instrument?
Yes, that's for the financial institution. That's why that part was did. It wasn't necessarily for JEA to only look at that, because that's the only thing they did was look at that, but it came as a whole packet for the financial institution. Okay. So on January the 25th was the second time that I sent the email asking for help in resolution before I filed the suit. JEA responded again on January the 29th by email stating that they once again refused the tender. Those documents that I did send show notice of tender of performance, refusal by JEA to accept payment, and then non-processing. Within the admitted contract relationship, I have acted in good faith throughout by submitting the tender, following up in writing, and asking for assistance before filing, yet the account continued to be treated as unpaid. I can also show concrete damages and ongoing consequences. The bill still contains delinquency and disconnection language, and I have receipts from certified mail and related costs, and because the dispute was not resolved and the account was treated as unpaid, I continue to make monthly payments to avoid adverse account actions. Even if the terminology in the original filing was imperfect, Rule 12 asks whether the well-pleaded facts state a plausible cause. These facts reasonably allege breach of non-performance, failure to process payment tender in a contract-consistent way, and the case should be decided on the merits, not dismissed with prejudice as frivolous. And for these reasons, I want to respectfully request reversal and remand. Thank you.
Thank you. You still got your rebuttal time.
Good morning, and may it please the court. My name is Charles Barnett, and I represent Michelle Williams, the Chief Financial Officer of Jackson Energy Authority. This is a case that presents a straightforward issue. Can a consumer satisfy a utility bill by taking the utility statement, writing hand by hand, pay to the bearer of as if it's a check, and then submitting it back to the utility company? We would submit that Tennessee law is clear that you cannot do this. The appellant, just talking about what occurred on August 6th, she sent a letter to Jackson Energy Authority, and in that letter, she wanted to renegotiate some of the terms that are contained in JEA's utility rental application. With that letter attached to it was a power of attorney that she had signed over herself, granting the power of attorney to herself. A letter of redress, a notice of claim, and then the check. And the check, what it consisted of.
All this in the record?
Yes, Your Honor.
Okay, go ahead.
What it consisted of was just the utility bill. There's a bottom portion of it. She had torn it off and wrote "pay to the bearer of" as if it were a check. As this court knows, that's not a check that JEA never agreed to open any kind of interest-bearing account or any kind of agreement to accept a negotiable instrument like this. We told her that as much by letter. This lawsuit was filed. The one issue that I would bring before this court, and we referenced this in our brief, is that the trial court, when it awarded attorney's fees, it did so under 20-112-119C. And under that statute, it does not allow for a governmental employee who's been sued in their official capacity to receive attorney's fees on their claims. And we would submit here, and I believe that the trial court's record reflects this, that she was sued in her individual capacity, Michelle Williams, and that an award of attorney's fees under 20-12-119C would be proper. However, if that's not the case, 29-20-113A, which is a part of the GTLA, authorized suits against attorney's fees against employees, governmental employees, when they're sued in their official capacity.
Did you request attorney's fees from the trial court under the 113 statute?
Your Honor, I do not know what is off the top of my head how that was requested.
I know you raised that in your brief, as I think you proffer that as being a clearer
Yes, Your
way
Honor.
for fees to be awarded to JEA, but I was just curious as to whether you requested them under that statute.
Yes, Your Honor, we requested them under that statute, and we advanced in the theory that we advanced at the trial court. It was that she had been sued in her individual capacity, so that would be the proper statute for awarding attorney's fees. I think the court would be empowered to do the same under 29-20-113A. I don't believe that it limits it to solely an employee when they're in their individual capacity. But in either case, in a situation like this, the court was empowered to award attorney's fees, whether she was in her individual capacity or in her official capacity. If the court has any other questions, that's...
Well, let me ask you about the attorney's fee issue.
Yes, Your Honor.
Apparently, we've got 2 defendants, correct?
Your Honor, I believe that there's only one defendant, at least since this was appealed to the circuit court from General Sessions. If you look at the trial transcript on the technical record on the first page, Michelle Williams is the only named and listed defendant, and she's listed as such in the style as well. The only time that JEA is referenced is when it's in connection with Michelle Williams being the chief financial officer. Now, I do understand that when she filed this, when the appellant filed this appeal, that she only included the name of Jackson Energy Authority. And I don't believe that the General Sessions civil warrant is in the technical record, but I believe that it included both Jackson Energy Authority and Michelle Williams. But at the circuit court, the petition, it only has Michelle Williams as the defendant.
Okay. All right.
Thank you, Your Honor.
Ms. Allen, you have, I think, 3 minutes.
Okay, I would just like to correct some things that he stated. Michelle is no longer part of the case. The reason why she was listed from the get-go is because she was part of the timeline. She was the first one to receive the documents. So when he says that she was the only one on the claim for the appeals court, no, circuit court, that's incorrect. It was JEA is who I'm going after. JEA is who I signed the contract with. All the materials that he's referencing, as far as that I sent, are part of the tender packet that needs to be together for the financial institution to approve the, to have the paperwork on hand. The bottom line is that they're still ignoring the tender that I sent. JEA agreed to accept payment and process it, so that's what I sent to them was payment by way of tender. And the payment part, as far as them refusing it, that needs to be reviewed up under the...
Research this issue to see if there has been any other cases where a tender has been made by signing a bill and referring it back to the billing party?
No, I have not had, come upon any cases. The only thing that I'm going by is the UCCs. So the UCCs that I'm referring to is 47-3603, which is when a debtor tenders full payment to the person entitled to enforce, that tender discharges the obligation to the extent of the tender, and an unjustified refusal affects the creditor's rights. I allege that I tendered full payment and that JEA refused to accept it. Another one is 47-1304. There's a duty of good faith in the performance and enforcement of every contract and UCC obligations. I allege that I acted in good faith and that JEA's refusal to even consider the tender is at least a plausible lack of good faith. So the only thing that I need is to basically have it reversed for remand so that I can go over the merits, which is that I'm in a contract with them and that their duty with the contract is to accept and process my payments. And we never got past that part. So then that's when the merits would come into play.
Thank you.
Okay, thank you.
Thank you, counsel. We will attempt to get you an opinion at the earliest possible time. Thank you. You may be dismissed. May call the next case, please, Miss Angie.